You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 109, How to Respond to a Patent Infringement Complaint. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. A few episodes ago, I talked about what goes into a patent infringement complaint. This is if you want to sue someone for infringing your patent. In this episode, we're taking the other side, how to respond to a patent infringement complaint, because you just got served a complaint where someone is suing you for infringing their patents. Now, when you respond, it's called an answer. And how you answer is going to depend on a lot of factors. It will depend on the strength of that the patent owner has, the strengths of your defenses, the possibility of whether you can countersue them in what are called counterclaims, the possibility of filing a proceeding not in federal court, but at the United States Patent and Trademark Office, and the possibility of whether you just want to settle early. These are all factors to consider when deciding how you want to answer when you receive a complaint. In this episode, I'm going to go through a bare bones approach. For an example, if you receive a complaint and you read the patent that they say you're infringing, and you just don't think that you're infringing because the products that you sell are different from what's being covered in their patents. As I mentioned in the last episode about writing a complaint, you have 21 days to file an answer or file some kind of motion in federal court. You can come to some kind of agreement to file later with the attorney that filed the complaint, but assuming there's no agreement, you have 21 days to file. So let's go over a sample answer. I talked before about pleading paper. On the first page of this, you're going to have some information about the parties involved and what court is going to be on the top half of the first page. Then in your first heading, you might have something like defendant's answer to and defenses of and counterclaims to plaintiff's complaint for patent infringement. What you do is you follow the paragraph numbering of the complaint that you received. If paragraph 1 of the complaint says that the party that's suing is a California corporation having a certain address, then in your paragraph 1, you'll actually probably want to deny that you have any knowledge of this. You'll see a lot of this in an answer to many types of legal questions. If you don't know something for sure, you can just deny it. You might say, defendants are without knowledge or information sufficient to form a belief as to the truth of the allegations set forth in paragraph 1, and on that basis, deny them. And in your next line under parties, you can write the same thing. Now, if the allegation is something that you know about because it's about your own business, like it lists your corporation address, you can just admit that. There's no reason to fight things that are obviously true. But don't be tempted to admit everything. And, maybe you think it's true, maybe you don't know if it's true. But if you don't know that it's true 100%, then just say you don't have sufficient knowledge to form a belief. And if you know something is false, you can just say defendants deny allegations set forth in paragraph 10 or whatever it is. You don't need to go into any explanations. Just say that you deny it. You can change your answers or kind of modify your answers later when you get knowledge of things later on in litigation. But it's better to be safe and just deny the allegations up front if you don't know that everything is absolutely true. Then there might be a section on jurisdiction and venue. I talked about that before. Jurisdiction is whether it's in federal or state court that's handling it. And which court it is the venue. So if it's Los Angeles or San Francisco or particular courts in those regions, that's venue. The plaintiff may assert that this is a patent case and it belongs in federal court. That's fine to admit because that's where patent cases are held. But venue can get really tricky. Maybe federal court is the right place, but federal court in Los Angeles isn't the right place. Maybe you think there's a better location for this. So you might deny that venue is right. Again, you just go paragraph number by paragraph number from the complaint and see whether it's something to admit or to deny, and when in doubt, deny. Then you might have a section where the plaintiff asserts certain patents. So you'll have a section with a heading called Asserted Patents. If they say that they provided a certified copy of a U.S. patent with the title as an exhibit, you might admit that on its face that what they attached appears to be a patent with a certain patent number. You might want to add a sentence that says, unless expressly admitted, defendant denies the allegations set forth in paragraph X, which is whatever paragraph they're talking about. There's lots of things you don't really know about the patent. So you don't want to admit everything. You just might want to admit that it appears to be that they attached a patent. The patent might list an inventor on it. Do you want to admit that that's the inventor? Maybe not. The patent office didn't investigate who the real inventor is. They just took it on faith that the party that filed the application was truthful about who invented it. But you don't know what the truth is, so be careful about admitting things where you actually don't know the answer. You might have a section called Claim 1, infringement of the patent. That's if they asserted that you infringed Claim 1. If you don't know what the claims are, if you don't know what claims are, then this is a hard place for you to start this episode. Go back, listen to my episodes about parts of the patent and claims. The plaintiff may have set forth multiple paragraphs about how your product is infringing. You'll want to mirror those paragraphs and say, defendant denies the allegation set forth in paragraph 30 or whatever paragraph it is. On the next line, say, defendant denies the allegation set forth in paragraph 31. And you just keep going until you match all the paragraphs that you had and just deny them. Don't explain them, just deny. If they had a section on prayer for relief, you also put in a section called denial of plaintiff's prayer for relief. And you'll say something like, defendant respectfully requests that the court deny plaintiff's prayer for relief as stated in the complaint. Then after this, you might put in some defenses. You might have a heading called First Defense, Invalidity. Remember that just because they got a patent doesn't mean that they should have gotten a patent. What you probably want to allege is something that says, the patents in suit are invalid for failing to comply with one or more provisions of the patent laws, Title 35 U.S.C., including, but without limitation, to one or more of 35 U.S.C. sections 101, 102, 103, and 112. I've talked about all those sections before in this podcast, and these are the requirements that you have to fulfill to get a valid patent. 101 is about subject matter, like you can't get a patent on a mathematical formula. 102 is about novelty. You can't get a patent on something that isn't new. Section 103 is about you can't get a patent on something that's obvious. And Section 112 has a whole bunch of rules in it about the descriptions in the patent and how sufficient they have to be. So you want to assert that their patent is invalid because of at least one of these. You might have another heading on the limitations of damages. Maybe they filed their complaint too late, so the statute of limitations has passed. There could be all kinds of reasons why their damages could be limited. There are all kinds of other defenses that you might want to list. Maybe they never marked their product with patented, so you were never aware of a patented product. You will want to write a sentence about failing to meet that requirement. You might have another heading called unclean hands. This is a doctrine where even if they might have a valid patent, there's something that they did that was so horrible and egregious that they're actually not allowed to enforce their patent. And this is partly what's called inequitable conduct. There could be all kinds of things that are inequitable conduct that lead to unclean hands. You might have a defense of license and patent exhaustion. Maybe you legitimately bought their product and you modified it legally, and they think that you're infringing, but you're actually not because you legitimately bought their product. There are all kinds of headings that you could have for this type of defense. Other ones, I listed a few of the big ones here that come up all the time. But in this part of the litigation process, you don't go into details like saying their patent requires parts A, B, C, and D, and my product only has parts A, B, and C, so I'm not infringing. That doesn't go in this part of the litigation. You'll have an affirmative defense that just says defendant has not infringed, does not infringe under any theory of infringement, any valid enforceable claim of the patents in suit. It's very broad, very general. You'll get into all those details later in the litigation process, but not in this answer. You can also put that you demand a jury trial, just like they demanded a jury trial, and you put in your own prayer for relief. And your prayer for relief might have some of these types of sentences. You might say that the court enter judgment in favor of defendant against plaintiff, that the court find the patents in suit not infringed by defendants, that the court find the patents in suit invalid, that the court find the patents in suit unenforceable, that the court finds this case exceptional under 35 U.S.C. 286, and award defendant its cost and fees in this action, including reasonable attorney's fees and prejudgment interest. And you might end with that the court grant defendants such other and further relief as it deems just and proper. Just in case you missed anything, if the judge finds something else that you should get something else, that's fine too. You don't want to miss out just because you forgot to include it, specifically include it in your prayer. And that would be the end of the answer for the complaints, but it doesn't actually need to stop there. You can have counterclaims. Maybe you have patented products and you believe that the party that is suing you was actually infringing your own patents. So you start a whole new section called counterclaims. And you really just go through exactly what I went through in episode 106 about the complaint, because this is your complaint against them. Instead of suing them in a whole new complaint, you keep it all together in one case. And you go through the parties against, all the same headings, the jurisdiction and venue, the patents that you think are being infringed, and all that good stuff. And you end with a prayer for relief. But this time, what you pray for is that the court find the other party infringed your patent and all the other things that you alleged. And that's basically it for a basic answer to a patent complaint. As I mentioned, how you answer is going to depend a lot on a bunch of different factors. You might want to settle quickly because you realize that you actually were infringing or it's not worth fighting. You're going to want to discuss all these strategies with your attorney if you ever get served with a complaint and you need to respond. And please contact an attorney right away because you do only have 21 days to respond. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.